In this video, we'll discuss the difference between civil liberties and civil rights and what they're all about. One of the ways to get at understanding civil liberties and civil rights is to ask ourselves this big question: when is it okay to break the law? You probably have all broken the law in recent days, probably speeding somewhere. Some of you have maybe committed slightly larger crimes, hopefully nothing too big, but we have our own individual justifications for when it's okay to break the laws that are set before us. And we have two very different thinkers on this matter. For Martin Luther King, you should Google his letter from a Birmingham jail. In this piece, he discusses when he thinks it's okay to break the law. And for Lincoln, you should Google his Lyceum speech, the full title being On the Perpetuation of Our Political Institutions. These two pieces of political writing give us the two choices of how to answer this question, and you have to choose between them which you think is better. Basically, MLK says that when a law is unjust or in violation of a higher law, it is your moral obligation to break the law. Not just that it's okay to break the law, but you are obligated to break unjust laws. And that's quite a radical point of view that most people end up siding with in the context of civil rights, but it's a pretty dangerous viewpoint because your sense of justice and right and wrong is probably different from many other students and many other citizens. Lincoln, on the other hand, argues we should never break the law. We should obey it in all its particulars until it is changed because we have political processes for changing the law, and we should go through those. So Lincoln's argument is that if everybody just takes justice into their own hands, we have no law, it's meaningless, we have no order, and our whole society will crumble. So look over those two pieces of political writing, if you can, and see if you couldn't have 1-minute debate between yourself, but pretending to be MLK and pretending to be Lincoln, or find another student to have this debate, and see if you can play out their different arguments and the strengths and weaknesses in them. Some of the ways we answer this question is relative to you. What argument works for you in your personal sense of justice? Unfortunately, we can't have everybody getting their way. We have to make rules for society at large, and that's really what the process of politics is all about. How do we take our individual understandings of justice and make rules that apply to all of society? So if you remember back to our discussion of Federalist Paper number 10, it was all about controlling the people. And Federalist Paper number 51 was all about controlling the government, using the same logic of dividing and separating powers and having checks and balances. So in the same way those two papers relate to the people and the government, we have civil liberties and civil rights representing those two quadrants as well. Civil liberties are those things written down in the Constitution that protect you from the government. So our Bill of Rights, for instance, is a whole list of things the government can't do to you. Habeas corpus, for instance, is the rule that you have to be brought before a judge in some reasonable amount of time for a hearing so that the state can prove they have some evidence to charge or hold you. Otherwise, they have to release you. Ex post facto laws are laws that would make something you did 2 years ago illegal today and somehow punish you for that, which sounds crazy, but the king used to do that in England. So as I mentioned, the Bill of Rights is our list of things the government can't do to you as an individual. And that's a protection for you as a minority from the majority. Every law we make is a decision made by majority power. Well, sometimes the majority wants stupid things, like let's kill or deport everybody named Mark. We don't want that to happen. So we write down, you know what, no matter what the majority decides in any given year, there are some things that the government cannot do. And we write those in our Bill of Rights. One example is religious freedom. Sometimes we hear this phrase that there's a wall of separation between church and state, and that's a phrase taken from Jefferson's writing, but is not actually in our Constitution. Our Constitution says there will be no established religion. So most court cases dealing with church and state have to do with, is the state favoring one religion over others, which would constitute some kind of established religion. But there can be plenty of religion mixed into politics. There's nothing in the Constitution against that. Only the favoring of one single religion is unconstitutional. We have some other Bill of Rights protections like the freedom of expression, you have free speech, though there are some exceptions, and that freedom is not absolute. Things like yelling fire in a crowded theater, you're not protected there. You can't say you want to quote unquote kill the president. That is considered seditious speech, and you can get arrested for that. We have certain tests that the Supreme Court has established to see if your freedom of speech is protected or not. If what you're doing presents a clear and present danger to others, we can say you're not free to make that speech. Also, on a lesser threshold, we can say if what you're doing has a tendency to lead to bad things. For instance, you're standing around and sort of inciting a riot, or the things you are saying would have a tendency to lead to harm, we may be able to restrict your freedom of speech. Occasionally, the government can make an argument that vital information should not be leaked by the media or the press, and that it can be restrained or held back prior to its publication. Things like national defense. You don't really want the New York Times publishing the location of troops before they try to enter a country and take it over, because that would compromise that mission. So that's some speech that we limit in terms of freedom of press. We have a lot of issues dealing with what constitutes hate speech and what is free speech. This is a really hazy, foggy area. Is it okay for students on a campus, for instance, to write all kinds of racial things on a bulletin board? Is that free speech, or should we make rules that keep students from doing things like that? Right? We are balancing what we want our community to feel like versus how free do we want to allow speech to be. We have various other freedoms scattered throughout our Bill of Rights and elsewhere in the Constitution. One, for instance, of freedom of assembly. This is not an absolute freedom either, in that sometimes we allow towns to say that you can't loiter. Well, loitering is just you freely hanging out on a corner with a bunch of your friends. Well, sometimes we allow the cops to drive by and say, hey, you guys can't hang out here. This anti-loitering law stuff has come up against a lot of constitutional issues because the application has tended to be racially biased in terms of how often a bunch of white kids in the suburbs are being told to go home versus African American communities. But the point here is that these rights are hard to define. It's hard to figure out what things should we allow the majority to decide and what things should we protect no matter what. And even when we say freedom of assembly, it's hard to figure out exactly what that means. Some other rights that we have added along the way, for instance, are the Miranda rights, where you have to be read your rights when you're being arrested. That process comes from a court case, Miranda versus Arizona, where the courts decided that you should be told of your rights so that you can actually use them. In a funny example of how these rights are not universal, often in court cases in other countries that do not have Miranda rights, defendants will mention that they weren't read their rights, and the judges have to remind them that they've been watching too much Cops, basically, and that their country does not have Miranda rights. Civil rights are different from civil liberties. Civil liberties are your protections from the government. Civil rights are our protections from each other as a bunch of crazy people running around wanting to mess each other's lives up. So civil rights refers to all the things that we secure for equal treatment. And so all of that constitutionally comes from Section 1 of the 14th Amendment that has a clause that we call the Equal Protection Clause. It says that you have equal protection under the law. And we have used that to say that citizens must be treated somehow equally. And that's where we get all of our discrimination, legal and political doctrine from. This, in a specific sense, was applied to the historical event of African Americans pursuing their freedoms from discrimination and Jim Crow and the effects of post-slavery era America. Initially, here's some important court cases. Initially, in Plessy versus Ferguson, the courts decided that in the issue of schools that segregation was okay. It was okay as long as the facilities were equal, as long as the black schools were equal to the white schools, that separation was constitutional. Of course, the schools didn't end up being equal. But that issue as an idea was overturned in Brown versus Board of Education in 1954, where separate was found to be inherently unequal, and there's plenty of interesting social science surrounding that case. Though there are some who argue, since we end up with de facto segregation, not de jure, meaning by law segregation is illegal, but think about your lives when you look around your community. We live in a very segregated way. So there are some sort of rogue scholars who argue maybe we'd be better off under Plessy versus Ferguson, where as long as we're going to be segregated, at least we should have equal funding to schools. Because currently we fund schools primarily through property taxes. So if you live in a nice neighborhood, there's nice schools, and if you live in a terrible neighborhood, you have terrible schools. But in any case, this all centers around our hope that we can achieve some kind of equal treatment under the law for our citizens. Why all this has to go through schools is a mystery to historians, other than the fact that the school is public, so it's tax funded, so it's obviously government, and we can make that constitutional connection. Though it's sort of sad that we put our youngest citizens through all this mess of integration, discrimination, segregation stuff. Other civil rights issues that have sprung up in the course of American history in the pursuit of equal treatment under the law have been the women's movement, which is similar in some ways to the civil rights movement, the rights of Hispanics, as Hispanics grow to become the majority population of America in the near future, depending on projections. That seems really soon or maybe a little bit further away. It can be really hard to project demographics like that because though Hispanics currently have more kids at a higher rate than other demographics, they are also moving up the economic spectrum, and as you make more money, you have less kids. It's one of those weird inverted relationships in the world that poor people have more kids and wealthier people have fewer kids, so the rate of Hispanic population growth will probably lessen. So it's hard to project exactly when they will become the majority in America. Asian Americans have tended to have an easier time assimilating into American culture and have had fewer civil rights issues, though they've had plenty of their own history. Check out World War II internment camps, for instance. We have 6, 7, 8%, depending on measurements, of our population are naturalized citizens, which means they are immigrants that become citizens. That's a pretty big chunk. So we will see the rise of immigrants' rights as a civil rights issue probably in our lifetime. And Native Americans have been a tricky issue for us over time. First of all, we initially did not extend constitutional protections to them because we argued they had separate nations, right? So the Cherokee Nation. Eventually we decided that was silly, and so we now extend constitutional protection over Native Americans, but that was a big civil rights issue. In terms of pursuing equal protection under the law, we bump into really tricky political issues like affirmative action. How do we make up for a history of unequal treatment without being discriminatory to current citizens? One thing we know about wealth in America is that wealth is fairly static. Wealth is different than income. Anybody can get different jobs and go to school. But wealth, meaning wealth that is passed down through generations, property, money, holdings, is fairly static. At the time of the Emancipation Proclamation, African Americans owned roughly 1% of American wealth. In the year 2000, African Americans owned 2% of American wealth. So things are really static in that way. We try to overcome it with things like affirmative action to undo what years of discrimination have done. Of course, from a logical point of view, this unnerves many people who feel that they aren't getting jobs and just having to do with their race, which is a pretty tricky political issue.